Good morning, my name is Lorraine Walker, I'm the ACT Chief Magistrate. In the ACT we have a two-tier court system that consists of the Magistrates Court and the Supreme Court. The Magistrates Court is what we call an entry-level court, so everyone who comes through the criminal jurisdiction will come to the Magistrates Court first, and then if the matter is serious enough they'll proceed to the Supreme Court. Magistrates Court in the ACT is also a coroner's court, an industrial court, a family violence court, a Gallimbani court, a children's court and a Warrnambool court. So there are a range of types of matters that come before this court. Most people who come into the court system will have experience in the Magistrates Court. In terms of the magistrate's role, we're like a judge. In some places magistrates are called judges, but magistrate's a very old title for a person who decides issues between either individuals in a civil context or between the state and an individual. In the ACT, in criminal matters, at the first instance, we have what's called an informant. That's a police officer who brings the matter to court, and then a person who is the defendant, who is the person responding. So what does the court expect from you when you attend? The court expects you to take your case seriously. Be at court early. You may be kept waiting for a long time. It's a very unfortunate aspect of the court process. It's a little bit like going to the doctor. Sometimes you have to take your turn. You may be required to be all day at the court, so take that into account when you're planning. But you need to be there early so that the court can be satisfied that you have arrived on time and that your matter can be dealt with as quickly as possible. If you can't come to court for some reason, communicate with the court, whether it be by email or letter or having someone contact the court and tell the court why you can't come to court. And if, for example, it's because of a medical reason or some other reason, you need to have evidence supporting why you're not at court, because otherwise it will be treated as you simply haven't turned up. If it's a medical reason, have your doctor tell the court why you can't come to court, not just that you're unwell. When you come to court, dress and act respectfully to everyone that you come into contact with. That is, to the court officials, to your opponents, to the lawyers who are present at court and others around. This is a serious environment. You should expect respect in how you're treated, so you need to model that in your own behaviour. Be proactive when you're at court. Ask questions, get advice, tell your opponent or tell the court, the magistrate, what it is you want to do about your matter. We're here to progress the matters as quickly and as effectively as possible. If you keep quiet, we won't know what your view is. Raise any problems that you might have. You can't make the date that's been set for a hearing. You want to get a witness to court, but you don't know how to do that. You have a disability of some type, perhaps a hearing disability, a physical disability, or you suffer with anxiety. You need to tell someone so that the court can accommodate that. Be forthcoming when you're asked questions. You know your own circumstances best, and you'll be told if something isn't relevant. Now, all of this might sound quite daunting. The court's well aware that people who come into the court environment find it very stressful. And it will be difficult perhaps for you to speak up when you need to, but this is your own interests you're protecting, so it's for you to actually speak on your own behalf when you're not represented by a lawyer. The court will do what it can to make that as easy as possible for you. And finally, listen. Because whilst you're nervous, sometimes it's easy to miss things. It's really important that you listen to what is being said to you so that you can act on that. The court can't give you legal advice, but if you don't have a lawyer, the court, the magistrate or the registrar who's sitting will help guide you through that process. So it's important that you communicate and that you listen to what's being said to you. The court will try and assist you as best as possible.